Welcome back. My name is David Nachman. I'm the managing attorney at Nachman and Associates PC. We're a global immigration law practice serving international and national clients who transfer highly skilled workers to and from the United States. In this video blog, what I'd like to do is discuss some of the options associated with employment-based immigration, and specifically for those of you who are not aware of what's called the pre-certification process. What I mean by pre-certification is that when an individual is looking for an employment-based visa or green card in the United States, there are two ways in which they can obtain that visa. One way would be through normal channels, which we consider to be the labor certification process. The labor certification process requires the employer or petitioner or sponsor to make an application on a Form 9089, ETA Form 9089, to the U.S. Department of Labor. In that application form, the employer is required to show that there are no able, willing, and qualified U.S. workers who can take the job. What happens with the ETA 9089 form is that probably the law firm or the employer will embark on a regime of recruitment. And there are very specifically designated methodologies for doing recruitment depending upon whether or not the position is one that is professional or one that is non-professional. Specifically, that recruitment regime would include running 2 Sunday advertisements in a newspaper of general circulation, also possibly putting advertisements in a local ethnic newspaper, also possibly making a physical posting on the premises, and running a job order with the U.S. Department of Labor. Now, each one of these recruitment methodologies has associated with it a particular timing element, and this timing element, of course, and the whole recruitment process lays out in such a way that everything has to be done, and it's very time sensitive. So this is the labor certification process. Now, there are certain types of cases that are exempt from the labor certification process, and those are the ones that I'd like to discuss with you today. The labor certification process basically is what is referred to as the EB2 or the EB3. The EB2 case is a master's degree or its equivalent, which is translates into a bachelor's degree or its foreign equivalent plus 5 years of progressive experience post-baccalaureate in the field. That's a master's degree equivalent EB2, or an EB3, which requires only 2 years of experience on up. Anything below 2 years of experience would be considered an other workers classification under EB3. So those are the classifications that fall under the rubric of requiring a labor certification from the U.S. Department of Labor. That's done through what's called the PERM process. PERM stands for Permanent Electronic Record Management. And the PERM process is, again, it's a bureaucratic overlay on top of what we call the pre-certification process. Now, the pre-certification process is associated with EB1 and also some of the EB2 categories. The EB1 classification, the first one, EB1A, is extraordinary ability. Extraordinary ability classification is reserved for individuals who are Nobel Prize winners or are individuals who are highly regarded in their fields, and there are a number of factors which designate whether or not an individual is one who is extraordinary in their field. For example, have they made original scientific contributions or original scholarly contributions to their field of academic endeavor? Number one. Number two is, do they have professional memberships in professional organizations? Number three, are these individuals highly regarded by their peers and other individuals in the field who are also highly regarded in their own right? So that's the EB1A classification. Again, that's extraordinary ability. The interesting thing about the extraordinary ability classification is that it does not require a sponsor. An individual can sponsor themselves. However, the stronger case, of course, is one where the individual is sponsored. EB1B is for outstanding researchers. Outstanding researchers do require sponsorship. Outstanding researchers are individuals who have a certain number of years of experience in their research field. What you should know about the outstanding researcher classification is it's not necessarily reserved for academic institutions and for pharmaceutical companies and high-tech companies. We have successfully launched and had approved outstanding researcher classifications in the private sector, because outstanding research is also considered to be research and development. The third pre-certified classification in the EB1 area is multinational executive. Multinational executive classification is one that mimics the same elements as the L1A. That requires that the individual have worked for 1 full year within the last 3 years for an organization, which is a qualifying organization under the law. That's one that is a parent, subsidiary, or affiliate of a foreign corporation, and is transferring to the United States to either be a manager executive in that field, and the definition of manager executive is laid out in the regulations, or an individual who has specialized knowledge in the field. And that specialized knowledge has to be, again, managerial or executive knowledge. The individuals who have L1Bs do not qualify for multinational executive E13s. Those individuals who have L1Bs need to go through the labor certification process, generally, if there's not some other type of EB1 classification that might be available to them. For example, maybe outstanding researcher. So what we try to do as a firm is that we try to develop a path for our clients, whether or not they are, if they're seeking a green card, which would put them on the track of getting a pre-certified green card as opposed to going through the labor certification process, if that's possible. 2 other pre-certified classifications which warrant some discussion are in the EB2 classification. One of them is the national interest waiver. Like the E1A classification for extraordinary ability, the national interest waiver classification does not require sponsorship. For a national interest waiver, an individual must show that they are an alien of exceptional ability. The term exceptional ability is defined in the regulations as an individual who possesses a master's degree or is recognized as one who is exceptional or highly regarded in their field of expertise. The national interest waiver classification was developed by 2 very specialized cases. One of them is referred to as the Mississippi phosphate case. The Mississippi phosphate case laid out about 4 or 5 elements of cases that would be generally recognized as being in the national interest. The second case that helped to develop the national interest waiver classification was called NYSDOT, the New York State Department of Transportation. That case made it very difficult for individuals to obtain national interest waivers unless they could show that the work that was being done by the foreign national was intrinsic to the national interest as a whole, and that the interest in obtaining a waiver of the labor certification outweighed the country's interest in the labor certification process. A very, very difficult standard to overcome. The next pre-certified classification that warrants some discussion is one that many people thought went out with the old law, but actually remains as a remnant of the old law. It's called Schedule A, Group 2. Schedule A, Group 2 is for individuals who are exceptional in their fields. It's very similar to the national interest waiver. The legal standard is the same. However, it does require sponsorship, and the elements of that case are very closely linked to the EB1A classification. However, the legal standard is lower. And it's a strategy that we often use for our clients who fall in a realm which would be a gray area between the PERM application and a pre-certified classification. If you or any member of your staff have any questions regarding pre-certification or the labor certification process through PERM, we'd be more than happy to assist you. Please feel free to contact us. Our telephone number is 201-670-0006. You can call extension 100, that's my extension, or our office administrator at extension 107. You can also feel free to check out our website at www.visaserve.com for additional information regarding the PERM labor certification process or with regard to the pre-certification process. You can also email us at info@visaserve.com. Thanks very much for your attention, and we look forward to speaking to you in a future blog.